I'd like to call this meeting of the Speech Language Pathologist and Audiologist Advisory Board together at 1:36 p.m. Everyone just remember to mute your microphone if you're not talking at the moment, and then announce your name when you do speak so that the names can be recorded. We sometimes have people who like to watch our sessions. Angelica, would you do the roll call?
Yes, ma'am. Chevelle Bryant,
Here.
Dr. Tammy Camp, Dr. Kristen Culp,
Present.
Elizabeth Sterling,
I'd like to call this meeting of the Speech Language
Stacy
Pathologist
Poteet.
and Audiologist Advisory Board.
Present.
Sharice Andrews,
Present.
and Presiding Officer Sherry Sancyprian.
I'm here.
You have a quorum.
Thank you, Angelica.
Yes, ma'am.
The first item on our agenda is approval of the minutes from our meeting of September 8th. Those were sent to you in your board packet materials that you should have received earlier this week. Did anyone have any questions or comments about the minutes as they were sent to us? Hearing none, I would entertain a motion to approve the minutes as presented.
I move to accept the minutes as presented.
Was that Miss Andrews?
Yes, it was. So
Yes.
moved by Ms. Andrews and seconded by
Stacy Poteet will second.
you. Angelica, could you do a roll call vote?
Yes, ma'am. Chevelle Bryant,
Oh, this is in favor of approving the minutes.
yes.
Oh, yes, I approve. Yeah.
Sorry.
Aye.
Good.
Dr.
Thank you.
Dr. Culp,
I approve.
Stacy Poteet,
Aye.
Sharice Andrews,
Aye.
and Presiding Officer Sherry Sancyprian.
Aye.
Motion passes.
Thank you. The next item on our agenda is public comment, but we did not have public comment just in general response to our last meeting. So we can skip that item and we'll move on to item E. Wendy Pello is going to present the information on what we discussed last time, the possible recommendation to change our rules to better match with the new federal rules about over-the-counter hearing aids.
Thank you very much. This is Wendy Pello, Senior Assistant General Counsel. Agenda item F today is the proposed rules that we had discussed last time at your meeting on September 8th. And Nick had walked through these proposed rules. These were rules that were implementing Senate Bill 2017 from the 88th legislature, the regular session, and implementing changes made by the FDA in its final rules regarding over-the-counter hearing aids and prescription aids, hearing aids, and then also making some clarifying some of the requirements regarding medical statements for sales of hearing instruments to individuals under 18 years of age. This is related to the medical evaluation and the waiver requirements. And so as the chair stated, these are rules that will implement Senate Bill 2017 and also align with the changes that have made at the federal level, both in federal law and in the FDA rules. We had, as we said, we had talked about them last time. If the advisory board would like me to quickly scroll through those proposed rules and highlight those changes, I can do that, or we can move directly on to the three public comments that were received. So if it's helpful to quickly scan through what those changes were, we can do that as well.
I think everyone was here the last time. Does anybody
Okay.
need a reminder of the changes, or I think we went over them enough, not last time enough, that we can go to public comment?
Okay. Yeah, I just want to make sure I'm respectful of your time, but also want to make sure I don't skip over anything if you need a refresher what those are. Those proposed rules are in your rule packages. So you can see what those changes were, mainly, changing with definitions, updating references to federal law, making changes to removing requirements regarding medical evaluation and medical waiver requirements for persons 18 and older, and some little cleanup changes there. So we did receive 3 public comments on these proposed rules. One was from an individual, another comment was from the Texas Medical Association, and then another from the Texas Academy of Audiology. On the individual comment, and you were emailed those public comments, so you should have those. That first comment from the individual agreed with the changes that we were making regarding the medical waiver requirements, and thought that the changes were timely and necessary based on the the Federal Register and the FDA changes regarding the over-the-counter hearing aid market, and just expressed appreciation for ensuring that our state licensing requirements are contemporary and consistent with the federal requirements. And so the department appreciates that comment in support of those proposed rules, but we didn't make any changes in response to those rules. Didn't know if the advisory board had any comments or thoughts or additional input on that comment. Okay. If not, the next comment was from the Texas Medical Association. They had submitted a joint comment letter that was commenting on both the speech language pathologist and audiologist rules under Chapter 111, and then also the hearing instrument fitters and dispenser rules under 16 Texas Administrative Code Chapter 112. And the comment was the same for both, and it was relating to the medical evaluation that the TDLR was removing that required medical evaluation for the adult prospective hearing aid user from our rules, and they recognized that that change corresponded with the FDA rules that had removed that required medical evaluation. So they recognized that there was why the change was being made, but they had recommended that TDLR adopt rules containing the new federal, what they called red flag guidelines or red flag conditions regarding when a patient should be medically evaluated. You can see in their comment letter they had noted the changes we had proposed to rule, the speech language pathologist and audiologist rule, section 111.201, and then they had expressed concerns about removing those requirements and making sure that the adults had information about recommendations regarding medical evaluations. So they had recommended, like I said, putting in a new paragraph 4 in that rule under 111.201, including the list of red flag conditions. And so you see their proposed language, and they were making that change to your all's rules, but also proposing that same language either be added to the hearing instrument fitters and dispensers rules, or cross-reference back to the rules under 111.201. They did note that those red flag conditions that they put in their proposed rules, they track the red flag conditions and those requirements that are in the new FDA rule 801.422. In response to that comment, we had reviewed that comment, but disagree with making that suggested change for 3 reasons. The first is that the TDLR rules align with the federal FDA rule changes in terms of removing that medical evaluation and waiver provision. And that does align with the FDA rules. The speech language pathologist and audiologist rules and the hearing instrument fitter and dispenser rules have slightly different medical evaluation provisions, but both of those rules required compliance with the former FDA rules. 801.420, which was relating to the red flag rules, and former FDA rule 801.421, which were the medical evaluation waiver provisions. Both of those rules were repealed as part of the FDA rules, and the FDA put in a new rule, Rule 801.422, regarding hearing aid, over-the-counter hearing aid. New rule 801.42 is the prescription hearing aid labeling requirements. And so we felt our rules were aligning with the FDA rules. The second concern we had was at this point in the rulemaking process, we are limited in terms of the substantive changes that, making substantive changes at this point in the rulemaking process. And that's part of it is because the public has not been made aware of or given the opportunity to comment. If the department agreed changes would be made, which in this case we don't, but if they did, we would have to withdraw the proposed rules, start over and republish them with the new provisions or add them in the future. It is anticipated when you get public comments to rulemaking that there would be, can be changes made. But if the changes start being substantive, effective new parties, making requirements more restrictive, then there's restrictions on kind of adding that kind of substantive change at that point. And the third reason we were declining is we just don't feel this change is necessary. And the reason is TMA wanted to add the red flag conditions that are in that new FDA rule 801422, the prescription hearing aid labeling rule, and include that in the speech language pathology rule under 111.201 as new paragraph 4. However, paragraph 1 in that same rule already requires compliance with that same FDA rule 801.422. So it's already, those red flag provisions are already required through that existing rules. I think it addresses their concern about having the red flag conditions being included, but they're not spelled out because they're already incorporated as part of the requirement to comply with the FDA rule. So open that up if anyone had any additional comments or questions or thoughts on that comment.
I'm glad to hear the explanation because I actually thought it sounded like a very reasonable recommendation to have those red flags spelled out. It's a little scary to me, and maybe the audiologists have come to terms with it, but the fact that somebody can walk in and, buy a hearing aid without any help still seems crazy to me. And having that list for consumers to me would make a lot of sense. So I get that it's part of the federal rule and that our rules say that you have to comply with it. I'm still not sure that this is the best consumer protection move, but just because I can imagine someone going and picking out a hearing aid and there's not a list there of if you have pain, if you had dizziness, if you have this, then maybe you shouldn't be buying this product, right? But we are regulating audiologists, not the public, I guess, is the problem.
Sherry, this is Katie Bryce. I wanted to mention that the FDA does have very strict labeling guidelines on the over-the-counter hearing aids that do include a lot of consumer protection information.
That's helpful. I haven't tried to go look at a hearing aid in Walmart, so I don't know. But yeah, I just wondered how the consumers get that information, and just seeing us as a consumer protection source. If there's anything else we can do to protect consumers, I'm always interested.
Right, and the rule, the new rule, the FDA rule, the 801.422 it's about prescription hearing aids, and so there's requirements about the labeling on the outside of the product, but there's also labeling that's inside, and there's a list of red flag conditions that are directed to the dispensers of those prescription hearing aids in terms of communicating that to their clients. And so that's the specific list that the TMA in their suggested language was addressing in terms of including that separately or including that in the rule. It didn't seem to necessarily from their comment letter that it seemed necessarily it was in addition to, I'm not, can't read into it. They were proposing it as a separate requirement. Mm-hmm. Our thoughts on that is it's already included in that rule, and it's broader than that rule includes more than just that specific list of red flag conditions. Okay. I don't know if any of the audiologists had any or anyone else on the advisory board.
This is Kristen Cole. Yeah. I would just say that, definitely the labeling has what is necessary, whether people read it or not. It's not the issue, but we are somewhat resigned in that people are going to get them through whatever means, including their own insurance company, third-party groups recommending things over the phone who are not qualified to do so. It's a maddening part of our jobs these days. So, but no, I have no problems with the FDA's warnings, red flags, internal labeling. It's pretty comprehensive. So I feel like our laws are already referring to that and don't have to have it separate.
Thank you. I appreciate all the feedback and the input. And that's something the advisor later in the, wants to maybe consider that in the future. If they want that separate, then it's, again, that would be something you could do in a future rulemaking if that becomes an issue that if needs to be pulled out separately or highlighted separately, even though it's part of that requirement to comply with that rule. Okay. And then moving on to the third comment we received, it was from the Texas Academy of Audiology, and they had submitted a comment letter in support of the proposed rules for the speech language pathologists and audiologists. Just some highlights. They had commented that the proposed rules bring the rules in alignment with the FDA final rule regarding over-the-counter hearing aids. They appreciated and agreed with the updated definitions that align with the new classifications for over-the-counter hearing aids and prescription hearing aids, along with all the other rules that kind of follow those definition type changes. They appreciate the timeliness of the rules and providing some necessary clarification to the practicing audiologists relating to over-the-counter hearing aids. They also agreed with the changes related to the medical waiver requirements as they relate to persons 18 years of older. They had expressed that they didn't think that necessarily the medical waiver requirements brought a lot of public health benefit, and they kind of served as a barrier in a way to accessing and having access to hearing healthcare services. They also thought that those proposed rules aligned with the FDA's repeal of the requirement on the medical evaluation and those waiver requirements. They did agree with retaining the medical evaluation requirements, including the written statement from a physician for persons under age 18, and those are retained in the rules. That's also still in the statute as well, and under Chapter 401. And then basically appreciated the clarification of maintaining that medical evaluation waiver on file if it's provided. So in this case, it being provided to persons under age 18, or if it had been provided to other persons as well, but helping in terms of the record keeping. So we appreciate that comment in support of the proposed rules, and we didn't make any changes to those comments. I didn't know if the advisory board had any comments or thoughts or additional input on that comment. Okay. Well, those were the three comments that were received. I didn't know if the advisory board members had any additional comments or thoughts. If not, then we would be. Go ahead, sorry.
Thank you, Wendy. I don't see anybody else hurrying to comment. So at this time, I would ask for a motion that we recommend to the commission that they approve these rules as presented.
Kristen Culp so moves.
Seconded by
Sherry Sanders, second.
Thank you. Angelica, would you do the roll call vote?
Yes, ma'am. Chevelle Bryant,
Agree. Aye.
Dr. Kristen Culp,
Aye.
Stacy Poteet,
Aye.
Sherry Sanders,
Aye.
and Presiding Officer Sherry Sensibrian.
Aye.
Motion passes.
Thank
Right.
you, Angelica.
Thank you all.
And then we're on to item F on the agenda, which is also going to be Wendy's. It's kind of looks like some cleanup to me, several things that rules groups had recommended and we need to get moved forward.
Right. This is kind of a rules package with a variety of items that kind of a miscellaneous rules package. It includes the recommendations from two of the work groups, the licensing work group and the standard of care work groups, some recommendations that have come to the advisory board in previous meetings. Moving forward with that, it includes some rule review changes that the department staff had identified, a lot of cleanup and clarification changes, some updates to statutory and rule citations, and then it does include a technical correction from two previous rulemakings, the emergency telehealth rules and the comprehensive telehealth rules that followed closely after it in terms of technical corrections, removing some inadvertent leftover references to in person. So I will share those rules with you, and so we can walk through those just a second. And these rules are at the, this is our first review of these rules, and so these haven't been published yet. So if we need to make cleanup changes or any edits to that, we can do that. So I will share. Are you all able to see that? The draft rules.
Yes.
And Hilka, thank you. All right, just kind of walk through these, and feel free if I'm not, since I'm looking at my screen, I may not see hands, so please feel free to jump in and stop me. This is cleanup with just the authority and adding applicability. We've added citations here in terms of not just, these rules are not just implementing chapter 401 and then chapters 51 with our enabling statute, but there's specific provisions within this, these rules that are implementing various other statutory provisions that are found, whether it be criminal history rules, telehealth, telemedicine, teledentistry rules, the voluntary charity care status rules, and the human trafficking prevention training. So that's kind of what this list is. Just so folks know that where did some of these other requirements come from. And then adding a new subsection B, which is letting the licensees and the public know that it's not just these rules that apply to this profession, but also the Chapter 60 rules, which is the procedure rules of the Commission of the Department that apply to all of our programs, except in the event of a conflict. And then also the Chapter 100 rules, which are the general provisions for health-related programs. The program was first, speech language pathologists and audiologists program was first transferred. The Chapter 100 rules kind of dealt strictly with those standard care scope of practice rules and how that procedurally worked of going to the commission and what could be changed, what couldn't be changed. Those rules have now been expanded to include other items, so we've put this up here as notice. And this change also corresponds to a change later on about removing a provision back in subchapter O about rules. Cut to that. Examinations, this is about the jurisprudence exam. There are not any substantive changes here. What this is we're recognizing that there are two separate jurisprudence exams, one for speech language pathology, one for audiology. So this is just a cleanup and helping add some clarification for the reader. This subsection here in subsection C, which has just been in the past been a general provision, all applicants shall submit proof of successfully pleading jurisprudence exam. This provision is now being turned into specific to speech language pathology, and then a new subsection is added for under D for audiology, but no substantive changes have been made to these rules. 1150, this is that the technical correction from the two previous rulemaking, the emergency rulemaking and the comprehensive telehealth rulemaking that quickly followed after it. The emergency rules, the change got carried over, and so this is the correction. We had been very clear in those telehealth rules that we're removing those requirements for in-person supervision, and we had removed that in a variety of different rules and sections in those rulemaking packages. We had changed the definitions of direct supervision, indirect supervision to make it clear that you could do it through telesupervision or in person. It didn't have to be in person, and also had it added the new definition of telesupervision, which replaced kind of the phrase of supervision or telesupervision by supervision by telehealth. So this provision and under 11150E, this sentence has said all hours must be completed, and it used to say under in-person direct supervision. We removed the indirect up here, but down here in paragraphs E4 and E6, we had a few inadvertent in-person still left. And so we're coming back and cleaning those up. But the preambles in both of those rulemakings were really clear that that was the intent, was to remove the in-person. So that's what the change is. Here's the corresponding change that kind of what I talked about with the applicability in the rulemaking is this was enough time has passed. This was kind of put in as a transition when the program first transferred in terms of kind of operating that, the commission adopts the rules, but the department, proposes those and had the sites to the appropriate provisions in Chapter 60, and then also talked about the standard of practice rules under Chapter 100. Both Chapter 60 and 100 are much broader in applicability than just these cited. So it's more, I think it's more helpful to have the provision up front, and these provisions are necessary, and they're already incorporated into those rule chapters. 111, 151, this is just a cleanup, just a in a form and manner prescribed by the department, just using some standardized language. 111.151, this was the change that came from the licensing work group several meetings ago about the proof of licensure. And this had come up in the case of a licensee. If a client's asking a licensee, how do you show proof of licensure in an event when you're maybe doing telehealth or you're not in an office setting? And this was the language that had come up and from the licensing work group, was adding this new subsection E that upon request the licensee shall provide proof of licensure to the client by showing either a current license certificate, current license identification card, or the current results of a license search on the department's website. Maybe in a while since you've seen that, and then we just tweaked the title. So make sure everyone's still okay with that. All right, standards of ethical practice, code of ethics. This was just a cleanup to the statutory reference. The statute had changed in terms of citation before and after January 1st, 2021. So this was removing the old citation. Fees, we're just using standardized fee language for these fees that are cross-referenced. We're not changing any fees, but it's just updating the cross-referenced fees that are over in Chapter 60 with late renewal fees, dishonored payment fees, and then the fee for a criminal history evaluation letter. Screening procedures. This is the proposal that came out of the standard of care work group, and there was a report at the last advisory board meeting on this change. This was expanding what communication screenings may be in terms of including not just language and speech, but also cognition to determine. And so that cognition had been added, aspects of cognition, cognitive process affecting communication function, and we had added cognition into the list of language speech cognition. I do want to raise a question. A question came up, and these are draft proposed rules. We had in reviewing these, Governor's Office had a question about subsection B on this may, and whether, and I can make this bigger if you all need to, the may, should this actually be a shall? Our thought was, we've had the initial discussions internally, was that it should necessarily be may, because thinking communication screening was kind of the broad umbrella that may include a variety of assessments, whether it be language, speech, cognition, but not necessarily all of those assessments would be applicable to or would be necessary for each client or patient. But we wanted to bring that back and get clarification from the advisory board if that is accurate or not, and if we need to make tweaks to the language, we can do so.
Sherry, since they're bringing, that's exactly accurate. We might test all of those areas or only one, and so that's why it says may.
Okay. That's what we were thinking, but we wanted to double check if that was the case. So any other, now seeing this in a formal rule package, I didn't make sure if there's any other edits or comments or thoughts on. And then the last rule is the newborn screening rule, and this is just updating the rule citation to reflect Health and Human Services Commission, their change in the transfer of the early childhood intervention provisions to a different rule chapter. So that's just the update, reflects that transfer. So that's the end of that. So it's very small, but we wanted to move forward with the things we could. We had some cleanup that was kind of pending, but now that we've got at least two work group changes coming out, we didn't want to hold those and we could move forward with those changes. Kind of a simple, straightforward proposed rule. So any comments, thoughts, discussions on that rule package? Okay. I can revisit any of these rules if you need me to.
Sherry Sabrina, I think it's just lots of little cleanup that we've talked about over the last year or so.
Right.
And it's good to just get it all in one package and
Right.
with that. So if no one has a comment, then I would ask for a motion to recommend to the commission that they approve these changes as presented.
Yeah, and for these proposed rules, these would be going to the Texas Register. So we would get
Oh,
your
okay.
recommendation-
Sorry,
yeah,
they
My
just
just to-
apologies, Sherry.
yeah, to publish these in the Texas Register. So these are the first step of the process. Yeah.
And then they have to go out for public comment. In the
They'll go out for public
Got it.
comment. Yeah.
Okay.
We just thought while you're meeting on the other rule, we'll squeeze this little in and make the most of your time and get this moving.
Great. So would someone make a motion that we get these out, posted to the register then? Don't be
So
shy.
moved.
I
So
moved.
moved. Chevelle Bryant, so moved that we get these out to the Federal Register.
Okay, so moved by Chevelle Bryant, seconded by
Sherry Andrews, second.
Sharice Andrews. Thank you. And Angelica, you wanna take a vote for us?
Yeah. All right. Chevelle Bryant,
Aye.
Dr. Kristen Culp,
Aye.
Stacy Poteet,
Aye.
Sherry Andrews. Aye. And presiding officer Sherry Cyprian.
Aye.
Motion passes.
Great.
Great.
Thank
you,
you.
Val.
Thank
Thanks
you.
for those presentations, Wendy. Just trying to get
Thank you.
through all of that. I know it's a lot of work.
Thank you.
So we're up to the item G, which is recommendations for agenda items for our next board meeting. Does anybody have anything in mind right now that you know we need to put on the list? Anything, Wendy, obviously, if we are sending these last package to the register, then we'll have to put those on the agenda for next time for approval. Or
That's
recommendation to the commission.
correct.
Anything else? Katie, is there something you know of from the office?
This
If
is
anyone
Katie. I
thinks
can't
of
think
anything, y'all can definitely email me as well.
Great, great. So we'll hold off on choosing a date and time for our next meeting until we actually have content that we know we need to cover. And
Yes,
then
please.
at that time, Angelica will be in touch with us to schedule that.
Mhm.
Any other comments, questions, anything that we need to include in the meeting? If not, I will adjourn this meeting at 2:09.